Good evening, everyone. My name is Tony Verona, and I have the great honor of serving as Dean of this law school, the University of Miami School of Law. My first order of business really is to thank Assistant Dean Stephanie Cox and Events Director Annette Uges for doing a brilliant job in masterminding and orchestrating Dean Grossman's two-day visit to our Miami law family, ensuring that the inaugural Keith C. Wold LL.M. Distinguished Lecture in Maritime and International Law would go off without a hitch. And not only have we not had a hitch, the 2 days have gone swimmingly well, or maybe what I should say, given the theme, is that we've only had smooth sailing. So colleagues, students, friends, this is a very special occasion tonight as we welcome my dear friend, former colleague, and one of my closest mentors and role models, a dean who was instrumental in ushering me up the tenure track and into the dean suite, his dean suite. Dean Claudio Grossman not only served as dean at American University Washington College of Law for 21 years, but is, without any exaggeration, one of a handful of the most prominent scholars, lawyers, and jurists in international and humanitarian law in the world. Anyone who knows Claudio or knows of Claudio can tell you that he is a force of nature, a brilliant scholar with an endless list of publications, a savvy lawyer who is sought after by national governments and NGOs around the world, a preeminent jurist known for his fairness and even-handedness and equanimity, a polyglot who speaks so many languages that I've lost count, a walking, breathing, embodied United Nations, but also, and this is very important, a deeply kind, a very generous, and a very humble man. Dr. Claudio Grossman, in other words, is a giant of law and in law. We have Dean Grossman with us today as the inaugural Keith Wold Distinguished Lecturer in International and Maritime Law because of our distinguished alumnus and good friend to Miami Law, Keith Wold. I kid Keith and Jennifer about this, but I had heard fantastic things about Keith and Jennifer from my predecessor, the Dean Emerita, Trish White, who I'm so pleased is here this evening. But I didn't get to meet them until we had dinner last fall in Miami Beach. And I've been to many dinners with important stakeholders through my decades at HRC, at American, and now here. But this dinner took the cake. We ate a lot, we laughed a lot, we drank a little bit, and we sang. There was a sing-along during this dinner. It was a first for me. And I share this with you so that before I share Keith's formal bio with you, you will know how Keith is like as a person. He is a distinguished Miami Law alumnus that has accomplished so much as a professional, but Keith does it with good humor, goodwill, modesty, and truly tremendous kindness. Keith also has lived his life with tremendous generosity. It is because of Keith Wold's vision for our maritime and international programs that we now are able to host internationally preeminent scholars like Dean Claudio Grossman for distinguished lectures like this one and entire short courses and semester-long visits. Keith, what you are doing for this law school, for your law school, in elevating our maritime and international law programs in this way will have reverberations that will flow for many decades into the future. What you are doing will inspire bright law students to consider careers in maritime and international law. The programs that you are underwriting will inform our faculty's scholarship in these important areas. What you are doing, Keith, is essentially invigorating Miami law. So I thank you and I thank Jennifer very, very much. With that, let me share with you Keith's bio. Keith Wold is From Boca Raton, an attorney and private investor. He has been a member of the Florida Bar since 1980 and the New York Bar since 1982. Keith has practiced maritime law. This is a very modest bio, by the way, Keith. Very modest, and I am reading it anyway, but it's very modest. You hide your light, in other words. Practiced maritime law and was involved in the founding of the Broward County Environmental Coalition and the Tampa Bay Environmental Coalition. These are big deals, everybody. Keith is on the state of, this is what I added. Keith is on the state of Florida's Government Efficiency Task Force, on which he advocates for reform of the 1972 water management law in a very distinguished and effective way. Keith earned his bachelor's degree in geology from the University of Arizona, his Juris Doctorate from Nova Southeastern University, and his Master's of Law in Maritime Law from the University of Miami. So ladies and gentlemen, please join me in thanking and welcoming Keith to introduce our speaker this evening. Keith Wold.
Well, that was something. I really don't want to follow that. All I have to say is last night was wonderful, and what I hope for in the LL.M program really embodies all that Dean Grossman's students and his family and his children have embodied, which is to be very good practitioners, also be capable of guiding and bringing forth the best in the law and the development of the law. One child is a practitioner of law, very well known. The other is a law professor. This is what I hope for the LL.M students here. So I could say many things. Actually, everything I was about to say tonight was already said by Dean Verona. But just as an aside, as a personal note, who can learn an entire new language, Dutch, while becoming a tenured professor at a law school? Nobody but this man here. I really enjoyed meeting you, and he's also probably one of the best preeminent international advocates. But he not only understands the structure of advocacy, but he understands the heart of it. And as he was explaining to me some of the strategies that he used, which he's going to explain to us tonight, I hope, it was very fascinating, and I hope that you are too. Thank you very much, and thank you for being here.
Well, first I want to thank Keith Wold for his introduction. I had the opportunity to have dinner with him yesterday, and I appreciate his knowledge and human qualities. I think this law school and the legal profession is really fortunate to have you as one member and distinguished member of what is to be a lawyer and a person that is engaged with important values. So I feel privileged and honored to have met you and to be here today. I want to thank also my colleagues, Stephanie Cox, Bernie Oxman. They are tremendous assets for this institution as well. They are role models of what to do and accomplish as a member of the faculty. And I want to thank also to Annette Christine Hughes, who had to deal with the different logistical issues, and she did that very, very well. I also want to thank Tony Verona, your dean. He's a man with tremendous vision and with tremendous energy, and I think that you have won the lottery here in Miami by having Dean Verona. I know him very well, and this is not only a question of actions and enthusiasm, but also the belief in the rule of law and important values of human dignity, in an environment of pluralism, and diversity, and I think, as I mentioned before, you are blessed and you are fortunate to have him. Let me thank all of you also for being here and for hosting me. I think that Tony and Keith forgot something very important in my resume. My students say that when I teach in English, their Spanish improves. so, I'm sure that your knowledge of the English language will get deteriorated as my speech proceeds, but you will be learning some Spanish, which is a universal language, very important everywhere. Now, I will talk today about this case, a case filed by the plurinational state of Bolivia in its application, it was an application on April 24, 2013, regarding a dispute to Chile's obligations to negotiate, claiming that Chile had an obligation to negotiate in good faith and effectively with Bolivia in order to reach an agreement granting Bolivia a fully sovereign access to the Pacific Ocean. On July 15, 2014, Chile raised a preliminary objection disputing the court's jurisdiction. It was rejected on September 24, 2015, and then 2016, and then oral arguments were scheduled from March 19 to 28, 2018, and a final decision of the court October 1st, 2018. Now, today I will talk about the factual background of this case, preliminary objections raised by Chile, the court's decision. I will refer also to the strategies pursued by Chile and to the importance of the case. I was the agent of Chile, and my views are, of course, totally objective, but needless to say, criticism and different views in a university environment are totally welcome, and I will be surprised if that's not the case. But as a scholar, I try to have an approach with some detachment of what is going on. Before talking about these issues, I want to say something about the International Court of Justice. The importance of the International Court as a mechanism to solve disputes among states. And there is something interesting. Since July 2017, a little bit before a year that we had our case before the court, 7 new cases were filed and added to the court's docket. The court rendered 5 judgments and an advisory opinion. 2 of the, and then requests for the indication of provisional measures and 1 order on counterclaims. Provisional measures do not prejudge on the merits of a case, but order a country not to do anything that could render the result moot. That was the case India versus Pakistan on a death sentence imposed by Pakistan. You can understand. The court might decide that it was imposed wrongfully or not, but if the person would have been executed, the decision will come too late. Then the court is currently deliberating 2 cases relating to disputes between Ukraine and the Russian Federation, and on the other, and then a dispute between India and Pakistan. The decisions of the court also embrace almost every region, including Americas, Asia, Africa, and Europe. Recently, the court issued a decision on the case between Bolivia and Chile, and that allowed the court to really, among other things, decide on important matters involving the relations among states. And the most important topic is perhaps the issue when you have a duty to negotiate in international law, which is very important for the world peace and for the relations among states. Also, it decided, issued an advisory opinion on the legal consequences of the separation of the Chagos archipelago from Mauritius in 1965. And that this advisory opinion was and is very important to evaluate the role of General Assembly resolutions in terms of the generation of legal obligations. Usually, a General Assembly resolution will be declaring what is already existing or will be a step into the adoption of new norms. And then a very important judgment on reparations in the case concerning certain activities carried out by Nicaragua in the border area between Costa Rica and Nicaragua. And that was a very important case in terms of reparation for environmental damage. So you could see the court addressing important issues facing humans. Personally, for me, was also an important and a unique moment in my life, because I had been a political refugee from Chile. I had to leave Chile during the dictatorship of Augusto Pinochet, and I was asked to represent Chile in a case involving the rule of law. This was not a surprise to me because since the restoration of democracy in Chile, many of my friends were in the government, and there was, and I have a strong special connection with the country. But it meant something to me. And it meant something to me also appearing before the International Court of Justice. I had been involved in a prior case, but being in charge of the case again meant something personally in this case because of all the background involved. Now, involving the, let me cover first the factual background of this dispute, alleged dispute between Bolivia and Chile. You understand that when the King of Spain decided where the border will go between the different colonies, they didn't have the benefit of having a GPS or Waze or anything else. And the continent was pretty empty. It's a large continent. It takes more time to fly from Washington to Santiago than to Washington to Moscow. And Santiago is in the middle of Chile. Imagine what it takes to go all the way to Punta Arenas. So it's a gigantic region, almost without habitat. Well, there were habitats. When the conquest of Latin America took place, there were over 45 million members of indigenous population. In the 18th century, very few remained, around 2 million perhaps. And this was not only the result of policies whose purpose was the extermination of people, but it was also the result of illnesses and infection. But the point that I am making is that the borders were not very clear. And there were multiple wars in Latin America involving border determination. There was a war between Chile, Peru, and Bolivia in the second part of the 19th century that I'm going to avoid the details, that concluded with a victory by Chile. And as a result of that victory, Chile acquired a province of Peru, and Bolivia lost its access to the sea, the War of the Pacific. A treaty between Bolivia and Chile was signed in 1904, where Chile acquired absolute and sovereignty and sovereignty a perpetuity. That is the text of the Treaty of 1904. So absolute sovereignty and a perpetuity. In exchange for that, Chile gave to Bolivia also a perpetuity, the amplest and freest right of commercial transit in its territory and its Pacific ports, the ports to the Pacific, and the right to establish custom agencies in the ports which may be designated for commerce. In that case, they were the harbors of Arica and Antofagasta. Chile was also, in accordance with that treaty, compelled to build a railroad at Chile's expense between Arica and the Plateau of La Paz. The railroad was completed in May 1913, and at that time the cost was around $20 million, which today the value is around $500 million. Also, Chile had to assume debts of Bolivia in the disputed territories that belong to Chile. Perhaps through questions, I can give more background on the war that existed between Bolivia and Chile. The Chilean version is this. The Bolivian territory was almost without people. Approximately 90% of the inhabitants were Chileans, and there was a treaty that Bolivia will not raise taxes to Chilean companies. And if something would happen, there was a duty to resort to arbitration. Don't forget we're in the 19th century, and then where disputes were solved also by resort to military force. And then there was an earthquake in Bolivia, and Bolivia announced that it was raising the taxes. Chile asked for the arbitral tribunal, the composition of an arbitral tribunal to solve the dispute. Bolivia refused to suspend the application of the tax and order the collective expulsion of the Chileans from the Bolivian provinces. Chile declared the war, occupied, and moreover, Bolivia said, we have this pact with Peru, and in the sense of implying it's not only a problem with us, but with the Bolivia and Peru at the same time. So that's the Chilean explanation of what happened, and I'm sure if there are Bolivians here, they could enrich this discussion by providing their explication of this, and those are welcome here. Then, as I mentioned before, as a result of the war, the Treaty of 1904 was signed between Bolivia and Chile. I will leave, for the moment, Peru on the side. But to mention that in light of what happened in the 19th century, Chile felt and feels that this quid pro quo, let me say, obligations toward Bolivia, created a unique regime for a Mediterranean state. Over 200,000 trucks per year go through Chilean harbors. Also, so the position of Chile is that Chile did not encircle Bolivia. Also, the Bolivians can put their products through Peru or going through Paraguay through the Atlantic harbors, the Atlantic harbors on the other side. Bolivia had, of course, had economic development and reasoning by Chile is by no means this situation prevented Bolivia from developing itself. Now, there were different negotiations during the 20th century, and I will mention more about that when we get into the legal analysis of the case. But for negotiations and actions by Bolivia. For example, in 1920, Bolivia tried to seek a revision through a League of Nations of the Treaty of 1904, arguing reconsideration due to the treaty being, quote, inapplicable. The League of Nations decided that only the parties to a treaty can modify treaties, so it did not proceed. Then Chile had signed with Peru an agreement that the Chilean occupation in the north, including Arica and Tacna, two towns in the upper north of Chile, will go either to Chile or to Peru on the basis of a plebiscite. But then the two countries agree that there will not be a plebiscite and Arica will become Chilean and Tacna will become Peruvian. And there was a proposal, the so-called Kellogg proposal by Mr. Kellogg in 1926, before this decision proposing that Arica and Tacna would be given by Bolivia. Neither Peru nor Chile accepted that. And then there was exchange. I'm jumping some other, let me see, attempts by Bolivia or others, and then concerning the fact that Bolivia did not have sovereignty in the Pacific Ocean. In 1950, there was an exchange of notes between Bolivia and Chile, where Chile, with a formal proposal to enter into negotiations concerning the status of Bolivia. At that time, Chile was motivated by water. The north of Chile is the driest desert on earth, the desert in the north. And Bolivia, water resources included the Lake Titicaca. But nothing materialized, and this is very important, because the motivation of Chile was its own interest, access to water. And it did not do it on a sense of legal obligation. But there was a change of government in Bolivia. The new president of Bolivia said, I'm not going to negotiate with Chile until we have the same level of development, among other things. And Bolivia entered into an agreement with Peru, stating that the Lake Titicaca would be a condominium. So there was not any longer an interest on the side of Chile to enter into negotiation. The ambassador of Bolivia, who had been negotiating, asked for political asylum in Chile, so the whole thing did not function. There were more notes exchanged, but then Bolivia broke diplomatic relationship with Chile in 1960, arguing that Chile was using the waters of the river Lauca. Now, in the 70s, the dictators of Chile and Bolivia agreed to enter into negotiation on the basis of exchange of territories. This is the so-called Charaña commitment and declaration. And they had agreed on an exchange of territories in the northern border of Chile. You understand that Chile did not want to cut its territory in two. And then in accordance with the treaty with Peru, any change in the status of what had been Peruvian territories needed the authorization by Peru. So the government of Chile asked for the authorization of Peru, and Peru did a counteroffer, the internationalization of the city of Arica. And then the position of Chile was that Peru needed to answer yes or no, not to come with a counter proposal. And Bolivia changed also its mind, saying that it was not any longer interested in an exchange of territories with Chile. So the Charaña process failed. Resolutions of the Organizations of American States took place, 11 resolutions. All of them finished in 1989. The dictatorship in Chile finished in 1990. And those resolutions recommended negotiations between Chile and Bolivia. Chile did not vote in favor of those resolutions. And these resolutions are seen in Chile more than request for negotiation for those countries and as an expression of the political isolation of Chile when Chile had a dictatorship. No resolutions of the Organization of American States have been further approved since 1999. And you know, for the value of a General Assembly resolution, it's very important, among other things, whether they reflect an obligation, and there are many ways to measure this, including the continuity. There are no further resolutions of the Organization of American States since 1999. An assembly of the Organization of American States took place in Bolivia a couple of years later, and it was not approved any resolution involving this situation. When democracy was restored in Chile, democratic governments of Chile opened negotiations with Bolivia to facilitate access, to talk about the possibilities, for example, of a zone where Bolivia will have a more control about different things. All the democratic presidents of Chile went into this, from Elwin to Piñera. But the negotiations were broken always at the last minute because Bolivia wanted sovereignty. And Chile didn't have any political conditions. These are not, let me say, empty territories. These are not occupied territories. The war of the Pacific took place more than 100 years ago. There are hundreds of thousands of Chileans living there. You can understand that giving away territory and sovereignty is not an easy task, particularly when it involves hundreds of thousands of people. Now, so these are some of the backgrounds that I think is important to understand the context. Chile presented a preliminary objection, claiming that the court didn't have jurisdiction, based on the fact that the Treaty or the Pact of Bogota, that was the basis for the jurisdiction of the court, would require, would be open only for disputes that were not solved or governed in the past by agreements among states. The court rejected the preliminary objection presented by Chile and declared that the court did have jurisdiction, because the court said this is not about the Treaty of 1904. Bolivia is asking to negotiate. So if there are agreements later on with legal force, this matter was not solved by 1904. Irrespective of the merits of that decision, at that time, the decision of the court was celebrated by Bolivia and not by Chile. And it's very important to know that you don't count your money while you're sitting on the table. And I thought later on that, you see, Chile played Brazil in a game in the World Soccer that took place in Brazil, the World Soccer competition. And in the minute 90, for those who know about soccer, the Chilean almost scored a goal that hit in the frame of the Brazilian side. And, but it didn't enter, and then the game was decided on goals. I mean, afterwards, you know, shooting to the arc. And Brazil won. And the Brazilians celebrated the victory. And then in the next game, they went to lose 7-1 against Germany. So perhaps would have been better for the Brazilians to lose the case. And perhaps for Bolivia, it would have been better to lose the preliminary objection, because they could have kept the historical narrative and the legal claims alive. Now, the decision. The first thing that I want to say is that if you are before the court, it's very important to understand the nature of a court and the role that politics can play before a court, in particular, explicit politics. For example, the president of Bolivia, and that was the choice, no criticism, went to the oral argument and went to listen with almost all the presidents of Bolivia, the statement except two, the decision of the court. Some Chileans thought they know, there was somebody got to know what is the decision of the court. How? Because if you bring a president to a court, I mean, you don't want to subject that person to embarrassment of a negative decision. I was the only one sitting on the Chilean side, the agent, and there were no ministers of foreign affairs, former president, or nothing. I mean, second thing, Bolivia made during the oral arguments and in all their pleadings a lot about topics of perceived historical injustice. At a certain point in the oral arguments, also one of the Bolivian lawyers said Chile wants to change the title of the court from Court of Justice to Court of International Law. But I want to bring to your attention that states have accepted the court's jurisdiction on the basis that decisions will be adopted on legal grounds. They can decide otherwise. But in this case, not because Chile doubted the justice of its case, something that happened in the 19th century, but the court has jurisdiction to decide on the basis of the law. And then the Chile kept that narrative, while Bolivia had a different narrative. Now, Bolivia argued before the court that bilateral agreements, including the exchange of notes, unilateral acts, statement by Chilean authorities, acquiescence, meaning not reacting towards a certain proposal with legal consequence, estoppel, when you do something and the other party trusts you, is an expression of good faith, and then they act or do not act, but that creates a detriment or something in your favor. If somebody says, for example, I'm going to, I promise you to sell you my home, and then you don't buy another home, for example, because you are trusting that, and then the person says, I changed my mind. That's estoppel, to put it very simply. There are a lot of complications. Bolivia also argued legitimate expectation, which is estoppel without a detrimental requirement, meaning I had the expectation that you would do something. I'm summarizing here legal notion. And then they argue resolution of the General Assembly of the OIS and the Charter of the United Nations, Article 2, Paragraph 3, and then the sum of it all, the cumulative effect. We argue, well, 10 times 0 is 0. If you cannot prove the existence of an obligation on the basis of all these arguments, all these, let me see, reason, you cannot claim that the aggregate at something. Well, the court rejected by 12-3 all the Bolivian claims. By doing so, they validated and let me see, the interpretations of the Vienna Convention of the Law of Treaty on how you ascertain a legal obligation, because this was about that, when you create a legal obligation. And Bolivia resorted to every possible argument to establish that there was an obligation to negotiate, as a matter of fact. And I think that their arguments were pretty good. If professors of international law want to see an analysis of how to generate a legal obligation, I think very complete texts are both the memorial and the counter memorials of Chile, because they show with extensive quotes to jurisprudence how you generate an obligation. Without a valid generation of an obligation, there is no duty. Some of the things, because of time. The court, of course, resorts to an objective interpretation. The text is the best expression of the intentions of the party. I'm a member of the International Law Commission. When the Vienna Convention of the Law of Treaties was being debated, the U.S. member McDougall tried to include in the norms of interpretation a view that the intention of the parties that moved them to sign a treaty was valid. The reaction of International Law Commission was negative because history is a pretty subjective field, as it is the law to a certain extent, but ascertain what people thought, when you sign something is not so easy. The nature of language means that what's reasonable then is not, might not be reasonable now. So Article 31 of the Vienna Convention of the Law of Treaties said the following. Establish a text-centered interpretation in light of its object and purpose, and looking at the context. But the context is the treaty itself, its preamble, other provision, and then, of course, subsequent practice. And you cannot restore to a preparatory work unless you achieve a result absolutely absurd or ill-founded. Well, so I'm going to spare different things here, but the court concluded that never Chile, as the text showed, had committed itself in the legal domain. All these exchanges, unilateral declaration, live in diplomacy. I must confess something to you too. We on purpose use the word diplomacy. And I think you might guess why. It's very important also to be very careful with the use of language. Politics, in many cases, brings a negative impression. So you say everything is politics, perhaps you create a problem. I'm not saying that the very savvy and well-prepared judges will be influenced by this type of consideration. But as a lawyer, you have to use legal techniques with tremendous care. Another important thing that we did was to create an alternative narrative. If you are saying no to a generation of obligation, unilateral obligation, no to declaration, no to a General Assembly, no to the aggregate of everything, no, no, and no, well, it's like, since I talk about soccer, playing a soccer game only with a goalkeeper. So you need, and this is a common trial strategy, you need to develop an alternative narrative. And the alternative narrative of Chile, including, among other things, explanation of the reasons why Chile entered into negotiation. Because of good neighbor, being a good neighbor. If Bolivia lived very passionately, the issue of its access to the sea was important to find possibility to even negotiate with them on the basis of the interests of Chile to see whether something could happen. So that was very important. Second component of this alternative narrative, as I mentioned before, no GPS or ways in the region with the King of Spain draw the borders. So if we would have allowed the questioning of treaties more than 100 years old involving borders, we would have opened, in the view of Chile, a can of worms that would have created instability in the relationships of different countries. The United States, Mexico, Bolivia, Paraguay, Peru, Ecuador, Colombia, Panama, I mean, every country. I mean, these borders were done with strife, with, let me say, with a lot of problems. And then the key thing was, don't touch. There was something else also. To establish a space for law and diplomacy. In Chile's view, and my view, I don't know whether that's the proper word, legalizing diplomacy. I mean, if you issue a statement, if you enter into negotiation, immediately that generates an obligation. Well, that would have meant the death of diplomacy. We live in a world where it's very important because of interconnectedness that countries talk to each other. And it would have been good in Verona for law schools if we would have said that every exchange required the presence of lawyers. A lot of people would have perhaps more work. But from the point of view of the conduct of negotiations and conversation, it would have created a tremendous problem in an interconnected world. Now, let me also, as we are concluding, to mention the following. The impact of this case in the relationship between Chile and Bolivia. First, this is a case, and as all decisions of the court, that is final. And that's important to take into account. Second thing, it reaffirmed the value of the Treaty of 1904, who has been a bridge between Chile and Bolivia. There has not been a war between the countries. Trade has happened. There are exchanges, and in spite of the fact that the countries that do not have diplomatic relations, and more could be done, there has not been disputes in this country that have resulted in the use of force. The same Treaty of 1904 says that if one country is not satisfied with the Treaty of 1904, can resort to an arbitral tribunal to complain lack of access by Bolivia, for example. That hasn't happened. So that was very important in terms of the relationship between Chile and Bolivia. It also showed that Bolivia doesn't have a legal basis also now. That does not mean that from the point of view of politics and that the relationship with Chile in Bolivia will continue to be to have strong economic and strong emotional and political connotation. But from the legal point of view, the court determined that there was not obligation to negotiate, let alone questioning the Treaty of 1904. Now, in terms of the let me see, the world at large, it reaffirmed the role of international law in settling disputes, giving securities to states that while we can have different interpretations of the law is a domain where we need to have those discussions. And the International Court of Justice is a place where those discussions with the different interpretations on the basis of an agreed common language will be solved. Particularly, the court also building on prior precedents illuminated us more about the obligations to negotiate under international law. Is there or is there not a general obligation? Well, again, in treaties, and I'm not going to get into that, you can establish in a treaty an obligation, and there are treaties that establish that. But in general, customary law, in the absence of a treaty, there is only an obligation when two claims overlap. Then the court needs to decide negotiation. And again, I will skip the impact on the the cases of North Sea continental shelf cases or the fisheries case and so forth. As example of treaties that establish an obligation to negotiate, you have Article 6 of the Non-Proliferation Treaty. And so that is very important. Second thing, the obligation to negotiate could be an obligation of conduct and of result. And again, I'm going to quote Article 6 of the Non-Proliferation Treaty and Article 83.1 of the United Nations Convention of the Law of the Sea. Because the obligation of conduct in a negotiation, you have an obligation to act in good faith, that the negotiation will be meaningful. But in the obligation of conduct, there is no obligation to have a result. And there are treaties, and I will skip those in this moment, where you need to do that. The court also explained more what does it mean to negotiate in good faith. Now, Let me finish where I started, with the topic of the value of the International Court of Justice and judicial decision-making mechanism. A few years ago, it seemed that the trends to globalization would strengthen international law. However, it is now necessary to revise our optimism. As the President of the International Court of Justice, Abdul Kawi Yusuf, stated in a keynote address before the International Law Commission, we live in a situation where it's important to play a role in responding, quote, to threats to the integrity of the multilateral system and continue to promote multilateralism and inclusivity, end quote, on the basis of the rule of law. Let me add that populism, and in my view, and nationalism, and chauvinism seek to free themselves as much as possible from the normal constraints of the rule of law. And that is a reaction not only against international law, but against the adjudication of issues through international tribunals and other type of tribunals, trying to free countries from every normative constraint. Political scientist Joseph Nye has explained, talking about this type of approach, that this has in international affairs dire consequences involving not resorting to soft power, cooperative approaches, and preferring hard power approaches, focusing on coercion and military might. However, we live in an interconnected world. We have seen now with the health situation, we need cooperation. We need cooperation towards terrorism. We need cooperation involving fair trade and system that allows everyone to compete, in accordance with certain rules. And decisions could be taken on the basis of different, criteria. One is with stronger, weaker, who claims to have moral or morality on their side or not. I bring to your attention, in the case of Chile and Bolivia, both countries thought that justice was on their side. Collective expulsion of Chile, Chileans, 19th century, breach of a treaty. The Bolivians didn't doubt about the justice of their side. I know very people who doubt about the justice of their position. So the value of the rule of law is that it creates a common narrative where we litigate those values, and the values of the International Court of Justice is that those different narratives are decided. And we see that there is space for that in different areas of the world. Let me say also that as we see these trends that are chiaroscuro, as the Italians say, because we have more interconnection and we have other trends, we should not forget the human factor and the role we play on this. I had the opportunity to witness when the Nobel Prize winner, Gabriel Garcia Marquez, on a meeting organized by the Inter-American Development Bank, said on the occasion of the start of the 21st century that people were asking him what we can expect about the 21st century. And writers have an ability with imagination to capture hidden aspects of reality, as Kundera said. And then Gabriel Garcia Marquez said, we cannot expect anything from the passage of time. I would add, except that we get older and with more problems, personally. But he said, the most important things that humankind has witnessed, like the Ninth Symphony of heart transplants, were in the imagination of people before they became reality. And I think we need to think how imagining the rule of law and contributing to it could shape this reality. where we solve disputes through a rule of law and through the judicial mechanism. Well, many thanks for your attention. Should I sit?
I think Bernie's going to say a few words.
I promise to be very brief. On behalf of the faculty and students, alumni, and friends of the law school, it's my honor to thank my esteemed colleague, Claudio Grossman, for his extraordinary lecture. And I just want to take the opportunity to invite you to link the remarks that he made at the outset of his lecture with the remarks at the end in order to emphasize its larger significance in his historical context. Professor Grossman and his colleagues on both sides participated in the peaceful resolution before an international court of law of issues that are eerily reminiscent of those that had occasioned a real war, as Professor Grossman pointed out, from 1879 to 1884, the Guerra del Pacifico, between Chile and Bolivia and Peru. And I think this amply demonstrates, as you concluded, that the rule of law does make a difference. I'd also like to add my own thanks to Keith Wold for his interest in developing our maritime law program. The lecture this evening is just the start of a host of new activities that have been rendered possible by his generosity. As Dean Verona indicated, with Keith's support, we will be bringing more visitors to our campus for lectures or short or longer courses that help to enrich our maritime curriculum and ensure that our graduate students in maritime and international law and our JD students with special interests in the field receive the best possible preparation for productive careers such as those that Mr. Wold indicated. And we hope to engage more individuals with practical maritime experience in the intellectual life of our school, lawyers and non-lawyers alike. So let me take this occasion to alert one of the world's leading experts on maritime transport, who treated a lucky few to his penetrating insights at dinner last night, that we are already discussing ways to lure him back to a wider audience. Before inviting everyone here to join at the reception and the student lounge on the ground level, I'd like to ask Dean Verona and Professor Grossman to join me here. Professor Grossman, we would like to present you this evening with a token of our gratitude for your preeminent service to law and legal education, the University of Miami School of Law Dean's Award.
I think it's right there, down here. And Claudio, it's such an honor for me to have you be the first recipient of this Dean's Award that reads, presented to Claudio M. Grossman, Dean Emeritus, and Raymond, Geraldson Scholar for International and Humanitarian Law for preeminent service to law and legal education. For you, Claudio. Thank you. Thank you very much. And very special thanks to Professor Oxman, whose idea it was to invite Dean Grossman. So thank you very much, Professor.